it looks like former President Donald Trump might have to spill the beans on his legal strategy. The special counsel has filed a motion demanding that Trump disclose his oh-so-clever plan if he's going to use the advice of counsel defense in his upcoming trial. You know, the one where he's accused of trying to mess with the 2020 election results and cling to power. Yeah, those pesky charges. The allegations range from sneaking around with classified documents to strong-arming state officials into changing the vote counts. Trump, of course, is pleading not guilty to all of this and claiming that he was just following the advice of his trusted legal team, like John Eastman. You know, the guy who wrote that memo suggesting Vice President Mike Pence could just toss out the electoral votes on January 6th. Classic Trump, always blaming someone else. The special counsel, Jack Smith, just couldn't help but poke holes in Trump's claim. According to the indictment, Trump apparently chose to ignore or brush off the advice of other lawyers who warned him that his actions were a big no-no. Now Smith is asking Judge Tanya Chutkan to force Trump to make up his mind and let everyone know if he plans on relying on the advice of counsel defense at trial. Well, it would give the government a chance to dig up more evidence and challenge the validity of Trump's defense. Not to mention, if Trump goes ahead with this defense, he can kiss attorney-client privilege goodbye when it comes to any communication about it. Ouch, that could really come back to bite him. Legal experts are basically rolling their eyes at Trump's attempt, saying it's about as likely to succeed as finding a unicorn on a roller coaster. Why? Because he has to prove he acted in good faith and relied reasonably on his lawyers' opinions. Trump might have some troubles ahead. According to some experts, he might have to take the stand and testify in his own defense. But it's not all bad for Trump. Some people think he'll try to delay the trial as much as possible. This Dave Ehrenberg guy, a Palm Beach County state attorney, seems to think Trump's delaying tactics won't work. He says the case against Trump is incredibly strong, and that any attempts to derail it would likely fail. Apparently, there's a whole mountain of evidence against Trump. Phone recordings, emails, memos, you name it. It's gonna be one heck of a trial, that's for sure. And get this, if Trump gets convicted, he could be looking at up to 20 years behind bars. Now that's a sentence that even he can't tweet his way out of. The legal battle between former President Donald Trump and the Justice Department has gotten pretty intense. Trump's team is trying to delay the documents case until after the 2024 election, but the government isn't having it. They're saying there's plenty of evidence and access to it. In a court filing, special counsel Jack Smith's office argued that the motion to delay is just a way to ask for more time, and that there aren't any valid reasons for it. Trump's team wanted to push the case back until at least mid-November 2024, claiming they didn't have enough access to classified evidence, and that there were allegations of tampering with security camera footage at Trump's Florida residence. The defendants expressed their frustration with the limited temporary facility in Miami, where they could review highly classified records. However, the special counsel's office defended their actions, pointing out that they had promptly provided key materials, such as reports, transcripts, and interview recordings to the defendants. Despite the court's scheduling order allowing the government to delay production until just before trial, these materials were shared soon after arraignment. The government firmly stated that their production of unclassified discovery did not warrant a continuance. They explained that some delays in accessing documents were due to the sensitive nature of the materials, especially those retained by Trump at Mar-a-Lago. They emphasized that these challenges were specific to the case and not the fault of the special counsel's office. Additionally, they pointed out that Trump's team had the chance to review these materials, both in Washington, D.C. and Florida. All of this legal drama happened while Trump was facing 2 federal prosecutions, one with 32 counts connected to the Espionage Act and other charges in Florida. These charges involved mishandling records and allegedly obstructing justice by not returning them to authorities. As the courtroom battle continues, there is a lot of debate about access to evidence and when the trial will happen. People are curious about how this case will impact the political landscape leading up to the 2020. Fulton County recently became the stage for a captivating legal spectacle as Scott Grubman, attorney for Kenneth Chesebro, one of Trump's ardent election deniers, leveled accusations at District Attorney Fani Willis. Grubman's allegations of political maneuvering in the courtroom have raised eyebrows, with many recognizing the term projection taking center stage, as his own actions seem to mirror the very behavior he decried. On Wednesday, October 11, 2023, Within the walls of a Fulton County courtroom, Scott Grubman presented his concerns, contending that DA Fani Willis was trying to prosecute the Republican Party. Grubman's exact words were, "It's a serious issue, and I am not trying to point fingers or anything. But my reading of the state submission was essentially there was one question, and it was worded slightly differently, but essentially my read was, 'Are you a Republican?'" This statement serves as a prime example of projection, as Grubman simultaneously engages in political accusations while asserting he is not. Grubman's criticisms transcended mere accusation, delving into the intent of the prosecution, grounded in his interpretation of their statements. He claimed that the state's submission implied their interest in identifying Republicans among the jury pool. However, this interpretation diverged significantly from the actual question posed by the prosecution, which was straightforward. "Did you volunteer for the Republican Party?" Grubman's assumption that the DA sought to pinpoint Republicans appeared unwarranted, as the question was clear and did not align with the broader claims he implied. It's interesting to note that Grubman's accusations came tinged with irony, as the actions of his own legal team seemed to parallel the very political accusations he made against the prosecution. In essence, this courtroom drama exemplified a sort of political theater in itself, where each side pointed fingers and tried to paint the other as engaging in politically motivated actions. The judge presiding over the case, Scott McAfee, demonstrated little tolerance for Grubman's claims. He pointed out the attorney's apparent hypocrisy, stating, "I understand that's the theme you take away. But when we actually look at the specific questions, many of them were identical. You asked, just like the state, how would you characterize your politics? Liberal, someone liberal, conservative. You say, what political party do you identify with? Identical to what they're asking." Despite the judge's response, Grubman was not ready to let his accusations dissolve. He responded with a somewhat convoluted explanation, stating, "That's asking for which one? I think that is completely different, Your Honor. It's different to say, we want to know what political this is a political case. Yes, we should all know what political party. What they ask, they don't even try to pretend. What they say is, 'Are you a Republican?' To me, that's inappropriate."